Thank you, Chair and Commissioners. Well, the time has come, as it said in Alice in Wonderland, for us to wrap up the story. So I want to just give an indicator of how I am going to approach this. My closing address, because I did not have the opportunity at the time to do an opening, will to some extent refer to the evidence that you have heard. But I am also aware that these proceedings are being streamed live to members of the public in Guyana and other places. So while you may find that sometimes I refer to things which you already know, please grant me the indulgence of understanding that I am also speaking to a larger audience than those in this room. Now, I expect that you will not want me speaking for 2 hours, nor will those persons looking on and listening want to hear one person standing up and going on and on for hours. So what we have decided to do is we have broken it up a little bit, and Mr. Griffith will be also doing a presentation as part of the closing. But I think that we have to start first with where the law is. And the reason for this is because this is a constitutionally appointed commission of inquiry. It is appointed by the President by virtue of his constitutional powers, and you are guided in the conduct of your inquiry by the Commission of Inquiry Act. And you are asked to consider in your report different pieces of legislation. In fact, you will have to give deep consideration to certain portions of the Constitution and the Representation of the People Act. And I think I would be failing in my duty if I did not begin there, because after all, these are legal proceedings. We are here to see if the rule of law had been adhered to during the period of time of inquiry for this commission. So just as a reminder for those who are looking on, I have asked that your terms of reference be put up on the screen so that nobody will think afterwards, well, this happened or that happened, or I think this is important and the commission did not look at all of those things. So just to touch base, I will ask, could that be enlarged a little bit? I'll not wait because we know what the terms of reference say. Now, essentially, what we have to be sensitive to is informing the public about the terms of reference. And there are many reasons for that, which I will go into as we go along. I think one of the reasons is, one of the questions I've found people asking is, what is the purpose of this commission of inquiry? What's the point of this exercise? Have people not already been charged and are before the courts? So that is a legitimate question for people who might not be familiar with the law, who may not know what a COI is about. Younger people may never have had the experience of listening or viewing a COI. And I want to say that the first answer to that, and I want to place it on record in my closing, is that the public has a right to know. The public has a right to information about what occurred during that period of time, and not information which comes from the press or comes from things posted on Facebook or things shared on Instagram or other social media or WhatsApp. The public has a right to know what information was there and what information was reliable, because this is what the commission will be concerned about. And I say so because not everybody in March of 2020 was in Ashman's building. Much of the information they would have got at that time would have come from some of those very sources which I have just identified to you. And we do not want, I think this is a wonderful opportunity for Guyana, for citizens, to try to get a handle on what actually occurred and to sift the evidence and to sift it from primary and secondary evidence, which is something I will touch on in a little while. Now, why does the public need to have information and why does it have to be reliable? Because GCOM is a public institution and GCOM holds a position of trust and responsibility to the public. Now, I wanted us, as I say, I wanted to start with the law. So could you just put up quickly Article 16 of the Constitution on the screen for me? People talk about constitutional rights, but they think about constitutional rights in terms of their own rights, not in terms of their public rights. But what Article 16 says is that the principal objective of Guyana's democracy is to establish an inclusionary democracy by providing increasing opportunities for the participation of citizens and their organizations, that would include political parties, in the management and decision-making processes of the state, with particular emphasis on those areas of decision-making that directly affect their well-being. I think if we have to start anywhere, we have to start with Guyana's own constitutional description of what is a democracy. What is a democracy within the context of the Guyanese law and Guyanese life? Now, former Secretary General of the UN, Kofi Annan, once said that no one is born a good citizen, no nation is born a good democracy, and both are processes that continue to evolve over a lifetime. And this COI is part of Guyana's evolution as a democracy. It will contribute to Guyana's growth as a democracy. Let us not forget, I think anyone familiar with the history of Guyana will know that even before independence, Guyana was brought to its knees by divisive politics. And when the Attorney General came into the box yesterday and spoke about the preparations and so on for the election, it is quite clear that there are still hardliners in the political arena. And this is why the role of GCOM and its adherence to its constitutional mandate is crucial. That's one of the tests you as a commission will have to consider when you write your report. Now, I submit that poor, negligent, or dishonest decision-making by a state entity, whether it's GCOM or the GPF or any other state entity, which impacts negatively on the outcome of the electoral process, is contrary to the inclusionary democracy defined in Article 16. And I will ask you to so find. So I start off with the principles that we must consider. Why have this inquiry? If we didn't have this inquiry, one, the public would not have had a body of reliable information which was material to their consideration of issues which they were not hitherto available. But I think this is a good reminder to GCOM, or this should be a good reminder to GCOM about what the Constitution has put in place for it. And it should give a good direction or interpretation to say to GCOM, this is the power you have. With great power comes great responsibility. And we are saying to you, this is the power that you have. If you didn't know it before, this is what we are here to remind you about. And it also says to citizens who are affected by GCOM decisions, it says to them, this is what your election commission owes to you. And I think it is absolutely important for us to recognize that. It's all about, as we say these days, transparency and accountability. And accountability, because if there is no accountability via this commission of inquiry, and we only wait for cases to go through the distinct and separate processes of public prosecutions in the justice system, what we are doing is incentivizing the misuse of power. So this commission of inquiry, I respectfully submit, has a tremendously important role, not only in its finding of facts, not only in its interpretation of law, but also in its recommendations. Because in modern democracies, recommendations come from different sources. Recommendations for policy, government policy. So your recommendations will inform the decision makers as to what best practice might be in cases like this. Now, I spoke about trust in institutions, and I did not realize at the time, but in my reading I found that there is actually a body of scholarship which looks into the issue of trust in institutions and how such trust is measured. And if you will allow me just the opportunity to go into it. I asked myself the question, does GCOM inspire trust as an institution? And it may be one of the things the Commission may want to ask itself. I found this article, and it's co-written by a Guyanese lecturer by the name of Troy Devon Thomas, who I believe teaches or taught at the University of Guyana. And it's an article which was published in the Journal of Politics in Latin America, number 3 of 2015. It's to be found at pages 85 to 115. And I'm grateful to the contents of this article because I had not realized that there were mechanisms for measuring trust, the issue of trust in institutions. Regrettably, that particular study did not consider GCOM, but it did consider other institutions in Guyana. It considered, for example, the Guyana Defense Force. It considered the Guyana Police Service. And I digress to say that while generally trust in institutions in Guyana was found to be low, the lowest scorer was the GPF. And this is an article based on data around before 2015. So perhaps this will give us a kind of understanding of why the GPF found itself, or members of the GPF, found themselves doing some of the things which we heard that they did. So there is a mechanism to measure trust. It just shows you how important institutions are, institutions such as these are, and why we need to audit them to ensure that citizens can repose their trust in them. So what Mr. Thomas and his co-authors had said, that in identifying whether you can trust an institution, you look at what principles guide the operation of the institution. You look at whether the institution accepts those principles and adheres to them, and I'm paraphrasing what he wrote. You look at whether the institution recognizes its responsibility to adhere to those principles. And you look at whether the institution itself has mechanisms in place to hold itself accountable if it slips, if it does not adhere to those principles. Now, those are considerations I just throw out there. The commissioners, of course, you will write your report, but I'm simply here to suggest that these are some of the things you may take into account. Now, you have heard a lot of evidence. I don't intend to go through all of it. I will give you something of a chronology, if I can, because witnesses don't always, the witnesses have not always given the exact time or sequence, but I will tell you which witness I relied on more significantly and why. What you have had before you, what you will have to evaluate, is primary evidence, that is to say the evidence which came out of the mouth of the witnesses, their contemporaneous records, which we have provided in the form of audio-visual material and documentation. And we have secondary evidence, which may assist you, that is to say, documents such as the reports of the observer missions who were here, but whose reports were put in through other persons. And I think significantly we have reports from the Carter Center, the OAS, and CARICOM. I think we also have the Commonwealth Observer report in, but I will check the list. I know in any event that these are reports which should inform you. In looking at the evidence, I recommend that in finding your facts, you ask yourselves this question. I have this bit of primary evidence. Is it supported by other independent primary evidence? Is it supported or corroborated by other primary evidence? And secondly, is it supported by secondary evidence in determining how you evaluate any particular fact? I also think, and I'm just jumping ahead to find where I wrote it down, I also think and recommend commissioners that when you come to write your report, I respectfully say that you have no choice but to determine what standard of proof you are going to use. Now, from my reading, I have found that there are 4 options open to you, and I think the standards of proof are also referred to in some of the reports which you have before you. So we have beyond reasonable doubt, we have balance of probabilities, we have reasonable grounds to believe, and we have reasonable suspicion. My recommendation to you, and reasonable suspicion. My recommendation, very respectful recommendation, is that we cut off the top two. And the reason I recommend that is because we do not want to say or do anything which may suggest that this process is somehow tied to the distinct criminal and civil processes, which may affect the cases which are currently before the court. So for the avoidance of doubt, that's just my recommendation. I respectfully suggest that you throw the top two out. I recommend a third, and that is because what you have had in this COI is actually highly reliable material. And I thought that for you to apply the test of reasonable suspicion to material of that quality would not be appropriate. It would not fit well, because the evidence which you have before you is of a much better quality than that. So the test, the standard which I respectfully suggest that you apply when you consider, of course it's for you to determine, is that of reasonable grounds to believe.
These four options that you suggest or speak of have been used in other commissions of inquiry as far as you're aware?
Yes, actually the source material that I found this from was there is a sort of code to guide commissions of inquiry, UN code to guide commissions of inquiry, but the code is in relation to breaches of human rights generally. And the code, I can always provide a copy of the code to the commissioners afterwards, and they have said you must find or operate on using a standard of proof. So let's go to how we came about into the evidence which was brought before this inquiry. Notices were placed in a newspaper, for those who may have forgot, indicating that the commission was going to be sitting, and these notices were placed well in advance of the commencement of the hearings. So notices were placed in the newspapers, I believe it was also on television, and people were notified that this commission was going to be sitting, and there was an invitation for persons to come forward if they wished. Some people did, and the method of producing the evidence, generally speaking, was that they would come to counsel to the commission. Based on the material they had, they would have statements prepared which went through a very rigorous process, and they were required to ensure that whatever was contained in those statements was accurate. It is only if the witness agreed that it was accurate that the witness was asked to sign an initial. And those statements have been admitted in evidence before you as exhibits. They have then gone in the witness box and they have testified on oath, because the statements are not under oath, but the witnesses have testified under oath before you. So the rigors of being in the witness box and answering questions under oath is evidence upon which you can rely. There have been persons who have been summoned to this inquiry, and for one reason or the other have chosen not to participate. And I say no more about those who have chosen not to participate. But I think that those who have come forward whether of their own accord or whether via summons, should be commended for accepting the invitation, for seeing it as a responsibility that they had, for performing their civic duty by assisting the Commission of Inquiry. And in the case of one particular witness, who I think really deserves special commendation, that's Miss Alexandra Bowman. I think she has to be commended for her courage, and I will go into that further down the road. What does the Commission do? First, understand whether GCOM did what it was required to do or fulfilled its constitutional mandate. We have to inform ourselves as to who is GCOM. So what I've asked is that reference be briefly made to Article 161 of the Constitution, and that it be put up on the screen. There are two articles in the Constitution of particular significance to GCOM. And I mention Article 161 because this may be an area which I respectfully suggest you may want to consider when making recommendations. So Article 161 says, GCOM is an independent body. It is solely tasked with the responsibility of supervising elections in Guyana. It goes on to say how the commissioners are appointed, the chairman and 6 others. Now clearly the chairman is considered to be a significant player in GCOM because the chairman has to meet certain standards according to Article 161. That position is full-time. That person holds that office full-time. The person must hold or have held an office as a judge of a court having unlimited jurisdiction in civil and criminal matters in some part of the Commonwealth, or in a court having jurisdiction in appeals from any such court, or who is qualified to be appointed as any such judge, or any other fit and proper person. Chairman is appointed, and the wording of this is a bit difficult to follow, and in fact led to some litigation, which I'll also briefly speak about. The chairman is appointed by the president from a list sent to him of 6 persons, and he selects one who is not unacceptable to him or her. So the president has a list sent to him by the leader of the opposition of 6 people, and then he determines whether such a person is not unacceptable. If the leader of the opposition doesn't send a list, the president has the power to appoint. But once there is a list, this test has to be applied. It appears as though, as part of its evolution, political evolution, that interpretation of this section came up for consideration in the case referred to when the Attorney General testified yesterday. It's a nice read to understand the workings of the Constitution in the context of GCOM. It's a case of Zulfikar Mustafa and the Attorney General, 2019, CCJ 9, and it indicates that the appointment of a chairman is constitutionally supposed to be done in a responsible and reasonable manner, eschewing partisanship and seeking the best interest of the Republic and people of Guyana. So this gives us an indication that the constitution of the commissioners or the group of commissioners has not always been easy. There has been some tensions about the appointments of commissioners, the appointment of a chairman, and so on. And what we do know is the current chairman was appointed after the decision of this case from the CCJ, just a few months before the elections. Now, what's the commission's constitutional responsibilities? Under Article 161A, we see that the commission is given very high constitutional legal authority and a mandate. The Article 161A says the commission is responsible for the effective functioning of the secretariat, and that secretariat comprises the officers and employees of the Constitution. I have quite a bit more to say about this aspect of it when I analyze the evidence which has been laid before you, but I'm only for the purposes of explaining myself, saying why I will make the analyses that I make further down the road. Article 162, and I think I had asked for that to be put up on the screen as well, says that the Commission shall exercise general direction and supervision over the registration of electors and the administrative conduct of all elections of members of the National Assembly. But I think the one you want to really look at and pay attention to is 162B. GCOM shall issue such instructions and take such action as appear to it necessary or expedient to ensure impartiality, fairness, and compliance with the provisions of the Constitution or any act of Parliament on the part of persons exercising powers or performing duties connected with or relating to the matters aforesaid. Very broad and powerful constitutional authority has been given to this institution by the people of Guyana through its legislators. One of the things I think a citizen might ask himself or herself, and I'll just address it briefly, is how does the GCOM operate in relation to the Representation of the People Act? Well, the Act itself, Section 4 of the Act, makes it clear. ROPA assigns additional functions to the Commission, but it makes it clear what we as lawyers know to be trite in law. The Constitution is supreme. It uses the word defer in Section 4 of ROPA to say that in the performance of your duties under ROPA, basically you have to defer to the provisions of the Constitution. So it's not just a common law reminder that we have in Guyana, but we have a legislative reminder of this constitutional supremacy. So I will indicate that the person or the witness that I used as my lodestar in chronicling the evidence was Rosalina Rasool. And I chose her, one, because she was clearly a witness who was intelligent, articulate, familiar with the processes. in terms of hours spent at the sites in question, she was there for almost all of it. She had a large body of contemporaneous material which she had documented from 2020. She had recorded times when things occurred, and I think that she gives the Commission a good starting point to look at the evidence. Now, before we move on, I want to make the point that I will not be referring to the evidence of some witnesses, but I wish the Commission really would pay attention to them, because they have contributed in such a material way to the quality of what has been placed before you. Vishnu Prasad from GCOM, Anil Giddings from GCOM, the material they provided about the electoral process, not only in terms of registration, but what happens at polling stations, what is a statement of poll, who signs it, who has access to it, and who gets copies of it. I think that is absolutely important, because what we have here is we have a lot of attention placed by everyone to ensure that the lead up to the process for an election is hashed out, is fair. Parties are calling GCOM, insisting that things be put in place and so on to ensure that their voters are not prejudiced and that kind of thing. But I suspect what happened in this case is, by the time you come round to the returning officer's office, after the close of polls, you are not prepared, no one is prepared for things to go wrong. Because as far as you are concerned, the practice according to law and historically, you compare statements of polls with statements of polls. There's a great deal of transparency in the process before you get to that point. If we look at it, I mean, the system which is in place here to ensure that everybody knows how the votes are cast, how the votes are aggregated at the polling stations and so on, works well, it's fantastic. And a great deal of work must have gone into that over the years to ensure that that is in place. And what do we know about the outcome of it? Everybody says, listen, as far as we are concerned, these elections were conducted well. We had no quarrel about it. The GCOM staff who were at the polling stations, generally speaking, worked well. But what we also know, and it is an inference which I think you can draw, when you look at witnesses, when you hear from witnesses like Bibi Anisha Mohammed and Sais Narain Singh, what we realize is because the two juggernauts in the race, let me call them that, they are contesting in all the polling stations. They are contesting, or they have an interest in voters at all polling stations in all districts. They are getting their statements of polls. I don't think it is unreasonable for this commission to infer that after the close of polls on the 2nd, perhaps by the next day, the two juggernauts, as I refer to them, would have had the totals. You are entitled to draw that inference. And perhaps this explains or is an indicator of an explanation as to why things then went awry. Rosalina Rasul was also chosen because she was an observer. So she was the observer for AmCham. We had another observer who testified, Mr. Gobaya from the Private Sector Commission. But she was one of the local observers who played a very important role. So Rosalina tells us, and she has video, that at the start of the process, Mr. Mingo addresses the persons in the office of the returning officer. And we have video to show that Mr. Mingo explains the process by saying they will be comparing statements of poll with statements of polls, which we, as we understand the law to be, is provided for in the legislation. It appears as though this was the practice before. It appears as though up till the start of the count, this was Mr. Mingo's understanding of what he had to do.
You're saying, Ms. Rasul, this was her evidence?
Yes, I think, and there is evidence in a video, an exhibit, which the commissioners of course will also have. But let's back this up a little bit. We know that this was the agreed process because we had a commissioner, Mr. Sais Gunraj, who came and told you, listen, we had a meeting on the 25th of February 2020, which I think the CEO did not attend. But it was made clear that these were the protocols that were going to be followed for the March 2nd, 2020 elections. These were the protocols. This was told to parties, members of the public, and observers. So everything moves well for the 3rd. Nobody has any complaints. And they take the break at 8:32 by Rosalina's account. They take the break at 8:32 p.m. on the 3rd to return at 9 on the morning of the 4th. Everyone is there at 9. The returning officer is not there. There is no word from him. There is no account for his absence. There is no indication as to when he will be there or whether any of his election agents, which he's entitled to appoint before the actual election, we don't know if any of them is there. And what we then have is a convoluted process of delay, changes in procedure, a lack of transparency, a lack of accountability, and deliberate manipulation of the process to make it as opaque as possible, not only for the party agents who are entitled in law to be there, but for the observers who represent civil society. We are told by Ms. Rasul that around 10:32, the DCO comes into the room and says that Mr. Mingo is basically ill and so on, and shortly after he's taken out, and we have all the images of that. But what is interesting is within a short space of time after he's left, the DCO comes back and says, listen, he's better, he's going to be here to restart in 45 minutes. So if we have to time it from when Mr. Mingo went MIA, as I call it, I would say it was from 9 on the morning of the 4th. Because he didn't show up to the returning officer's office where he was supposed to be. There was no explanation given for his absence, and no step, nothing put in place to ensure that the ascertainment process continued. But one thing I would like to remind us of, and I think, even though I said I wouldn't go into his evidence, but I think it was Vishnu Prasad who told us that this process is really called an ascertainment process. We've heard it called many things. We've heard it called tabulation, counting, verification, but in law it seems to be that it's an ascertainment process. And what that process is, GCOM takes its statements of polls which it has received from the different polling stations and calls out the numbers so that the parties can check them against the statements of polls, which they have, so that the aggregate of votes is checked by the returning officer and, I suppose, added up in a manner which is transparent, not only for political parties, but for all citizens, even those who may not have voted or have had any interest whatsoever in the process. And what happens over the next 2 days is, quite frankly, nothing short of bizarre. I don't think any other word can occur to the mind of a reasonable person looking back. I accept that we are looking back to something which occurred then, and you have 2020 vision, and you are able to say this should have happened and that should have happened, or this could have been done or that could have been done. But even if you put in all those considerations, even if you plug them in, there's really no reasonable and lawful explanation for what took place over the next 2 days. And we've heard about it from any number of witnesses. We heard about it from, so you have primary sources of evidence. We heard about it from Rosalina Rasu. We heard about it from Assistant Commissioner Thomas. We heard about it from Mr. Aaron. We heard about it from Mr. Schumann. We heard about it from Commissioner Gunraj. We heard about it from Charles Ranson. We heard about it from Jonathan Yearwood. And for those who think mistakenly and misguidedly that this commission has a political agenda, or that the working of the commission has been infused by a political agenda, please put that out of your minds. We have had representatives from, I think, 6 political parties testifying before you, apart from the independent observers. We've had the URP. Now, I can't remember, to be quite honest, I can't remember which witnesses may necessarily belong to which party, but we have had the URP, the CGP, ANUG, the LJP, the PPP, and the Liberty and Justice Party. These people were adversaries for the 2020 election. But yet, when they come to give you their evidence, there is a remarkable coincidence in the account of what they have presented to you. Now, as any inquiring tribunal, you may ask yourselves, okay, Guyana is a small place, these people are all here, is it possible that they got together and cooked up this account of what took place? Well, I would suggest to you that that is something which you should put out of your minds immediately, because you have a good reason for so doing. Not only did they come and give live evidence, but they had contemporaneous records, audiovisual material, independently recorded, which they produced to you. So when they testify, they are not saying, listen, I'm now saying this for the first time since 2020. They have proof to say that I took a photograph when I saw this occurred, or I made an audio recording when I heard Mr. Lowenfield saying certain things, or I made sure I, grabbed a copy of whatever was available to me, and here it is. They have produced records to you. So I think we can safely put aside any question about political affinity in the conduct of this commission, in its inquiry, and certainly in its analysis of the evidence and its report. And this takes me back to the point I made, which is to say you have had a high quality of witness before you, generally speaking, for those very reasons. I'm aware of the time, Commissioners, don't worry.
No.
I'll stick within my time.
No. You go right ahead.
Yes. Now, one of the things GCOM has to do, and this actually became more and more important as the days went on, right up to the recount. One of the things GCOM is required to do is to provide facilities for party agents and observers. And basically that usually includes things like the chairs and tables, because we know that the statements of polls are quite thick, the bundles are quite thick. People are using their computers and so on. And all of this was in place. GCOM did a great job. All of this was in place when people started arriving at Ashman's building on the night of the 2nd. You have no complaint about that. Everybody was happy with the facilities on offer. And it is, I have to say, that it is just last night that it struck me when I was going over what I thought I would share with you and the listening public this morning, is when we visited GCOM and we realized that inside this building was filled with so much glass. There was so much physical capacity for transparency. But the actions of those who wanted to pervert the rule of law turned the GCOM into a dark and opaque place. And that could have led to very serious consequences for this country. I hope those who decided to take such actions as they did have by now recognized how dangerous what they did was to the legal and social and moral fabric of Guyana. At the end of the day, put law aside. Let's put law aside. But what did citizens expect of GCOM? To capture it, they expected GCOM to do the right thing, because they reposed their trust in GCOM to adhere to the law. And as you ask yourself these questions, we come back to the basic moral question of, did these people do the right thing? Sometimes we complicate things by looking to the laws. Lawyers, we're always looking to say, what does the law say? Did I meet the standard, or can I step out of it? Is there a little wiggle room there that I can twist in a word to say that what I did is within the law? But at the end of the day, we get back to the simple, basic moral question of, did they do the right thing? You will have to look at Mingo's conduct to say whether, not so much as, I suppose, Mingo himself, but what he did as a returning officer or didn't do. What was a returning officer required to do in those circumstances, and what did he or didn't do, or what did he did not do. So first of all, he is MIA at 9. He leaves the building. There's no communication with the people to whom he is responsible. Let us remember.
At 9 on the 4th on the
Yes,
4th.
let us remember. In that process, it is not the CEO and the DCEO who is responsible for the ascertainment. In fact, they are supposed to keep out of it. Wait until they get his aggregate. The CEO then has certain responsibilities to the commission, which oversees him. But what we slowly see, not only is there an apparent abdication of his responsibilities and duties by Mingo, but we see an insinuation by the CEO and the DCEO into the process which Mingo is supposed to be carrying out. Now, what legal authority allows this to happen? What's the line of authority or the legal thinking? What makes this right? And I respectfully say there was nothing which permitted the CEO and the DCEO to participate in the process that the returning officer was supposed to be conducting. To be fair to them, clearly you have an official who is MIA. But was the reasonable option not the option of saying, look, let me find out what's happening to this man and what arrangements he's put in place for the ascertainment process to continue, because I, as CEO, I have to give a report to the commission. Instead, what you have is the CEO and DCEO coming down and interfering in the processes which are supposed to be conducted by the RO. Why did that happen? The physical structure of Ashman's building and its layout, and indeed, when Ms. Myers had questions asked on her behalf, it opened my eyes to certain things which I had not previously seen. Look how this place is set up. We know in law, the structure is commissioners, secretariat, and in this case, because of the physical location, returning officer for District 4. Ashman's building is set up. CEO and secretariat at the top. This is a physical setup that they are starting with, which probably is an indication of their mindset as to what powers and authorities they have. The commissioners who are the top of the legal structure, they are given a space on the second floor. You have to be tagged. Came out from the questioning by Mr. Hughes of Mr. Gunraj. You had to be tagged to go up to command center, if I may call it that. The commissioners had no access to what was going on there. But I asked myself, what on earth was going on there? Because the returning officer's office is downstairs. We know the tabulation center where the CEO's statements and polls are being collected and added up is on the second floor, according to Mr. Giddings. The commissioners are in a space, well, it seems as though they are not sure that they are supposed to be there, what they are supposed to be doing, and so on. But one thing that is made clear to them is that you can't come up here. And there is something sinister about that. Why are the commissioners excluded from any part of the physical structure of a building in which they are supposed to be carrying out their constitutional duties? That physical arrangement, in my mind, is a reflection of how the Secretariat of GCOM saw itself. Secretariat of GCOM didn't see themselves as being responsible to the commissioners. They saw the commissioners as being responsible to them. That's the bottom line.
It does raise the question, who took the decision? Clearly not the commission, that they would exclude themselves from the third floor. So the question is, who took the decision to exclude the commissioners?
We asked Mr. Gunraj that during the course of the inquiry, and he did not know. All Mr. Gunraj knew as a commissioner appointed by the president is, listen, I didn't have a tag to go up there. The chairwoman went up because she was ill, or they perhaps allowed her up for other reasons, I don't know. But certainly there is no indication that any of the other commissioners were allowed there. Now, who could have taken that decision? It had to be the Secretariat of GCOM itself. Nobody else makes arrangements for the physical accommodation for an election apart from GCOM. So I think it is safe to infer that the Secretariat arrogated unto itself the constitutional powers and mandates of the commissioners. And not only did they take it on, but they used it to exclude the commissioners who were vested or invested with such powers. So while we start by thinking, listen, problems really started arising after the 4th, I think if we look at this a little more deeply, the problem existed before the election. We may now ask ourselves, well, why did the commissioners not do anything about it? I can't give you the answer to that one. And I can't suggest an answer to you, a clear answer. I can simply offer some thoughts. Clearly, the way this commission is set up, it's divided, it's partisan. In order to have a quorum, I think you must have two commissioners from each side. So even to meet, you have problems if there is an issue on which you are politically divided. All the commissioners have to do is stay away, and then the commission cannot convene. Perhaps the law with respect to that should change. Did the chairman exercise the powers which she had. I think before we make any analysis, we have to understand. This chairman, it appears, is not someone with a political background. She comes from a strictly legal background. She took on the job after there was high controversy about the previous person in that position. She was there for just a few months. Can she rely? Is she entitled to look at all of her commissioners as a resource? And I would say no. Because on partisan matters, they would be split. So does the chairman, perhaps, need to have her own independent legal advisor? Does a chairman of GCOM coming in need to have training in management skills? Perhaps. Because it seems to me that the chairman admitted that she did not know what to do. When the house started falling down, she says that she became essentially so upset that she couldn't
Be bothered.
well, I don't want to say that because the way I interpreted what she said was that she didn't want anyone to bother her at that time. She wanted some space. I think she phrased it quite unfortunately though. I didn't want to be bothered. It's not as though I am saying goodbye to all of you and I don't care what happens. It appears as though this lady had found herself in a position where she had never encountered something like this in her life and didn't know how to approach it. That's the bottom line. I'm not offering that as a reason. Or I'm not saying that that is right. But let's look at what the other commissioners were doing. Were they caucusing? Were they advising the chairman? Were they recognizing that they too had high constitutional rights and responsibilities? And apart from what we have heard about Commissioners Gunraj and Ben, it seems to me as though the commission was not really operating as a commission. You had commissioners overseeing different things. They were doing their authentication of the statements of polls and so on. But there was very little cohesion, if I may use that word, from what we have heard from the testimony between the commissioners and the chairman. So their oversight, I respectfully suggest, was deeply affected by this. For example, Mr. Gunraj gives us the explanation. He says, listen, at one point when we found out, I can't remember what it was, whether it was one of the spreadsheet incidents. But he says, listen, I went to the chairman and I asked for us to convene and we couldn't convene because we didn't have the numbers from the other side. So that process has to be examined very deeply because it could stymie, a process is capable of stymieing the exercise of a constitutional duty and detracting from the constitutional performance required of GCOM. I can't say that I'm a management expert myself, but these are just some of the practical matters that I think that we can look at. How is the fourth spent? Fourth is spent, absence of Mingo, then we have nothing really much taking place on the 4th. There is some counting on the afternoon of the 4th. We know from Ms. Bowman and so on what occurred. In the night of the 4th, going on to the morning of the 5th, we have the incident with the laptop. Well, first of all, we have the CEO refusing to find replacements for Mingo for the calling of numbers. Then when he finds somebody, we have a spreadsheet being used. I pause here and I like what the AG said. It added a little levity. But sometimes, you know, in the Caribbean, we say, if we don't laugh, we'll cry. And I think when he talked about from the spreadsheet to the bed sheet, I think that might be a good encapsulation for what I am just about to embark upon. So what we have is Alexandra Bowman, and I consider this woman to be incredibly brave and forthright. She says, listen, I was 7 months pregnant, I was on duty, I was called out, I had to call numbers. We had training that what we were supposed to do was to call out the numbers from statements of polls so that the political party agents could compare it with their statements of polls. She confirms that. She's the insider that we have. That's your insider witness. Not only does she say this was the practice, she says it was the practice for previous elections for which she'd worked. Ms. Bowman says that to the back right of the room was where the statements of polls were. And she made an observation which we didn't have before, which is to say that there were workers, GCOM employees, including one Enrique Laivan, who was at the back of that room, apparently working on something. She says, as far as she understood, the other employees were there to sort the statements of polls, and by that she means sort it according to sub-district, because that's how they were calling it. But these people are there doing goodness knows what at the back of the room. But the outcome of it, or the product of what Mr. Laivan appears to have been doing, is apparent to us. Because it was Mr. Laivan who came to Alexandra Bowman, who was prepared and trained to call from the statements of polls, and handed her, or she gave him her flash drive so that he could put a document on it, which she was to use to call. Do we know where that spreadsheet came from? Well, now we know the answer. We know the answer. Bowman gave us that answer. Who populated it? We don't have that answer. But this is not a question that needs answering. The point is there was a departure from the process and there was no explanation to the employee as to why this was done. Bibi Anisha Mohammed, we saw the flash drive. After the Laivan incident, we saw the laptop. We have the DRO who is working with Laivan, who is another insider, who says after about 10 minutes, Laivan just stops without telling him anything and takes the laptop and flash drive which he's using and walks out of the room. Now, apart from all of that looking very suspicious, I think the big takeaway that we could take from that, so we go from spreadsheet, I think the big takeaway we have to draw from this is delay. Who benefits from a delay? Where we can infer that the numbers were known to the two political juggernauts. Who benefits from a delay? Is the delay inordinate and unreasonable? I say yes. Because the CEO had given the commitment to all concerned, observers, political parties, and so on, that the process would start and continue until the end. This is what had been done in the other districts. The returning officer had given that commitment. This was not adhered to. Now, something struck me as odd, and I'll tell you what it is. In looking over the evidence, I've touched on the fact that there seems to be, an upside down perception of where the authority lay in GCOM. But I think there was also a sort of amorphous movement, if I were to put it that way, from the Secretariat of GCOM into the returning officer's space, legal space, I want to put it like that. And this starts when we have the Deputy CEO coming in, and not only saying that the ascertainment process is going to start back, but she says, as far as she knows, or she purports to say to the people there, that there are only 3 SOPs left. Now, this is not an official who participated in the process. There is no evidence that she was there during the course of all of the counting done before. As far as we know, her channel of information will be the SOPs going through Giddings' department right up to the CEO. That is her channel of information. How does the DCEO come to this position to come into the returning officer's domain and say, we are going to continue and we only have 3 SOPs left? And what makes it worse, according to Ms. Rasool, is when people said, no, hang on, it's quite a bit more than that. She begins to argue with them. So it's not an honest mistake. It's a position she's taken, that she's trying to force down the throats of the people in the office of the returning officer. As Ms. Rasool said, she engaged in a heated argument, that's to say the DCU, with the people in the room. Eventually, after much toing and froing and the parties having to call the CEO comes down. Does he disassociate himself from this process, which he told agents and observers would be followed on the 25th of February 2020? Does the CEO address that? Does the CEO make any inquiry? Listen, where did this spreadsheet come from? Why are you saying there are only 3 SOPs? No inquiry whatsoever. What do we get? More delay. If the returning officer doesn't declare, then the CEO can't report, right? And persons in office remain in office. We have so many people involved in this process who had legal authority, which they could have used to put things right, to have set this train back on its tracks, and failed to do so. One that comes to mind, and it is not an easy thing for me as a lawyer to say it about another lawyer, but it's the former Attorney General, Basil Williams. Because what struck me in reading over this evidence is while all of this is happening, it appears as though, and there is this discrepancy between the spreadsheet and the numbers on the statements of polls and so on. Mr. Williams is there. There is, while this election process is being conducted, there is a government in place in Guyana. Constitutionally, he is the legal advisor to the government. Nobody with legal authority intervenes to try to get this train back on track. No, but what we have instead, and to say if I have gone from bizarre to absurd, I can't say that I am good at mathematics, but I know addition. You learn it in primary school. And addition of numbers is not a matter of opinion. It's not subjective. And for an attorney general who is the legal advisor to the then government, to say to all those gathered there, international and otherwise, that these numbers are subjective is nothing short of absurd. The rights of voters, the rights of electors on that night were not protected by those legal entities and officials who had the authority to protect them. And we have him on video, so it's not just a witness coming to say so. Now, Lowenfield carries out, he goes away after being first told about this spreadsheet and so on. He goes away, does nothing. Spreadsheet continues. He is called back in. After they beg him, he does a sampling. And I am so grateful to this witness for her record keeping, because Ms. Rasool tells us that when the sampling was done from 3 ballot boxes, according to the spreadsheet, the votes for ballot box 4013 showed 242 for the APNU AFC. The votes according to the SOPs for that ballot box was 192 for that party. Ballot box 4014, the spreadsheet that they were using, which you don't have and which disappeared apparently, showed 215 for the APNU AFC, while the SOP showed 162. If the CEO thought that it was just the political parties making noise, then he now has evidence before him that he has seen with his own eyes that there was a departure between what was contained on those SOPs and what was on the spreadsheet. And he does nothing. He does nothing. He doesn't even make an inquiry. How this came about? Who was in here? Why did you all put this document put together? You don't have to be a CEO to ask those questions. Those are common sense questions that anybody could have asked. The commission has to meet before they stop using spreadsheets. The commission meets at the request of Gunraj, and it is only then the use of the spreadsheets is stopped with incorrect numbers and identified discrepancies known and seen by the CEO. What I thought was also interesting about this aspect of it is when we saw some of the video material, the people speaking up weren't only the parties, you know. It wasn't only the parties creating mayhem, as the former commissioner would like to have us believe. We hear the voice of Tenny Husty, an observer from the Guyana Bar Association, presumably someone who the CEO would consider as being a person who knows what the law says. And we have Mr. Husty on video talking to the CEO and saying, this is what the law says. And what do we get from the CEO? Absolutely nothing. And this is why I say, the stars of this inquiry are not only those who have come forward, but those who stood up for the right thing in 2020. So the voices you have heard in this inquiry are not only the voices of the witnesses, but you have audio and visual material to show who some of the protagonists were during that crucial time. Okay. Now, I want to stick to my timeline. So I'll just run through this spreadsheet to the bedsheet scenario, try to wrap it up a little bit because there are other things I want to talk about. We have bomb scare. Nobody leaves, not even GCOM employees. Ms. Myers is telling people get out of the returning officer's office, but she doesn't leave. The only people from GCOM who leave are the people who have a policy manual which tells them what they have to do in an emergency. That's the IT department. They leave. I don't know if Ms. Myers thought poor Mr. Giddings should have stayed, but it seems like she was upset about the fact that he left and he took the server out. Let me put this on the record before this commission. This commission summoned production of that server. And I had a duty to you as counsel, because remember, Giddings had said that he placed markings, he taped it up and so on to make sure there would be no interference. Server arrived here in answer to this summons, just as the photograph of it, which is before you as an exhibit. Someone else apart from Giddings was sent from GCOM to look at it. If I found anything wrong with that server, or if I found that server had been tampered with, or there was any evidence of it, I had to produce it to you. There was nothing for me to produce to you. It was still wrapped up just as Giddings had said, with the markings in the same place. And with your leave, I will have to ask for it to be returned to GCOM because it is still sitting in council to the Commission's office. So any allegation of impropriety there is just static. Let's just set it aside. The man did what he was supposed to do, according to stated policy. Was there any other car in the car park that you could have taken it to? Oh my goodness. He has a responsibility to act in a certain way in a bomb scare. You are in a secured car park. It's not as though he abandoned the server. He's waiting by the muster point, where we haven't heard Ms. Myers arrive up till now. So, bomb scare is taken care of. Poor ACP Thomas has one thing after the other because he has Livan, he has bomb scare, which he has to sort out at the building and try to apprehend who it is who made the call. He is at the building trying to monitor what's going on there and this kind of thing. And at the end of the day, what we have is, and this is important, and this is why I had thought that perhaps the witness who had been summoned, Trotman, may have been of use to us. Because Ms. Trotman has not been charged with anything. There was information which she could have given, but she chose to exercise her constitutional right. There is no allegation of impropriety against her. What is clear is that everybody was waiting in that room and had been told that the count was going to continue, the ascertainment process was going to continue on the afternoon of the 5th. So they all gathered there and they are waiting. But you know who knew that was not going to happen? I looked at the evidence of ACB Thomas. Azor calls him. Same Azor relied on his constitutional rights. Azor calls him and says, Ms. Myers just told me that an important announcement is going to be made. So Azor knows that an important announcement is going to be made. Myers knows it. And the people waiting in the returning officer's office, they have been told that the ascertainment is going to continue. That's why they are there. Mengo comes down, he indicates he's going to make a declaration. I don't think we need to trouble ourselves so much with this. I don't think anybody can dispute that that counting process, ascertainment process had been concluded. It had not. There is the clearest of evidence that it had not been concluded. So I don't know where he got his figures from. And then after Commissioner Gunraj tries to call him out on it to say, well, what are you doing and why and so on. He says, Gunraj says he's blocked by Myers, and then the returning officer goes up to Command Central, the fortress above the 3rd floor, and is not seen again. There was some lawfare, as I put it, at this point. Not warfare, but lawfare, because there were several cases being filed in the courts. And I think that we have to appreciate that some of the delay or some of the days lost were days simply because they had to wait for the courts to decide certain things. So they were due to finish the count 12th and 13th and so on. For no reason whatsoever, they go to a shed. And that's where we get to the bed sheet. Important things to note there. Rosalina Rasul, I think it was, and I think Jonathan Yearwood as well, gave evidence that whatever documents they were using to call from were being put up on this, this kind of
improvised screen.
Yes. And while that doesn't sound good and so on, it was important to note that some people couldn't see the figures properly, which was important for public participation and transparency and accountability. But what they observed is that some of the documents put up were altered. So Rosalina says in her evidence that she was not actually sure that they were calling from SOPs, or whether the SOPs that they had been using had been altered. But she waits until 10:41 that night when Mengo makes a second declaration, and this one is signed by Carol Joseph, who came before you and stood under the cover of her constitutional rights. She signed the form. She co-signed for Mengo. But before she did that, she'd spent her evening happily having a fight with the ANOG representative, threatening the head of the president of the Guyana Bar Association. And you will hear audio not only of these skirmishes in which she found herself, but you will hear this person so loud that you cannot hear the numbers being called. This is what we call a transparent, accountable process. You know, one of the EU observers gave a press release on interview or something, which I saw and which you may have seen a little while. And the man put it plainly. He says, we have to understand, you know, people are not fools. The people of Guyana are not fools. What happened there was abysmal, nothing short of it. So, I segue now, if I may, into why I think the conduct of some members of the GPF must be looked at, must be addressed in your report.
Let's show, we need to have a short break before we really wait. And you give me 10 minutes.
If you want to give me 10 minutes, no problem. Sure.
Right, 10 minutes.
You look very tall today. Oh, okay. You have blue and I